Hello, everyone. Welcome to this fourth and final symposium of the IPDLN. It's an absolute pleasure to be here with you. Obviously, I'd much rather be in Australia right now. I'm calling you from London during our second lockdown. But nonetheless, it's truly an honor to be here with speakers I'm being joined by today, who will all be talking about various aspects to do with data and well, law. My name is Matthew J. I will introduce myself properly a bit later. We're going to have four presentations, about 10 to 15 minutes. I'll introduce each speaker as they come on. And then we'll have plenty of time for Q&A at the end. So please do, while the questions are fresh in your mind, type them into the Q&A box and we'll get to them, get to as many of them as we can at the end. So first of all, we have Betsy Stanko. Betsy has extensive experience working with data. She's a social scientist in academia and government. She's going to talk to you about her experience with police data. She's also, I hope I get this right, an external advisor to the Ministry of Justice on the Data First Partnership, which we'll also talk to you about now. I'll let her say anything else she wants to say about herself. And so without any further ado, over to you, Betsy.
Great. Good morning. Sorry, this is just my technical expertise. There we go. Good morning, and it's very nice to be with you today. What I'd like to do is talk about the hybrid experience that I've had using data, both as an academic and thinking about the ways in which systematic inquiry enables you to think differently about what organizations do, but also the ways in which one then has to translate that into a much more strategic approach to data across the board. And I spent 25 plus years as an academic in the US and UK, as well as then joined government, cabinet office, Metropolitan Police, and the Mayor's Office for Policing and Crime, devising a strategic way to using crime data as just ordinary administrative data. Being on the inside has really aided my ability to do quite a lot of work. And so my hybrid, which was being what I call my totem animal, which is a chameleon, to be able to be inside and thinking like an academic, but inside an organization. So I've used my experience both in policing and in the mayor's office as a way of trying to introduce administrative data into organizational strategy, decisions, and assessments of outcome. Because the important thing about the way policing counted its work when I joined in 2003 was that it just counted. It basically talked a lot about whether crime was up or down, but it really didn't talk about where it was, who was doing it, why they were doing it, and also beginning to apply a really rich data set, which was where I was, the Metropolitan Police, the largest police service in Europe, to be able to apply information that they were collecting day in and day out as crime data, to apply that to their strategic thinking. So I began to look at both locations, but also people as well. And I'll talk more about that as we go along. My journey started in 2000 when I did some work with the Racial and Violent Crime Task Force. I did strategy around hate crime, domestic violence, rape, and homophobia. We were in the unit that introduced, for example, the first markers around religious hate crime, particularly after 9/11. And we were able to then begin to pick up instances of hate crime and violence, which might have been directed specifically at people for who they were, basically. What was important is that this is a real goldmine to me. I spent a lot of my time as an academic working with women who had experienced violence, domestic violence, sexual violence, and basically much of that work was off record. We couldn't get access to information and data. It just wasn't possible. So I basically was studying silence. When I walked into an organization, what I found in terms of thinking about justice was that much of what we were talking about, we being feminist researchers doing work on violence against women, was absolutely in the data in a really, really strong way. So what that gave me was really clear, good motivation to begin to look at all kinds of different things, organizational behavior, organizational decision-making, and to begin to use that information to begin to help steer senior, because I worked for 6 different commissioners. So I worked at the top of the organization. I worked also in something called performance, which meant that I was able to wrap organizational knowledge to outcomes. Sorry about the little bits that are here. That's just my inability to fix that before time started. What we've learned about through the pandemic is really that continuous assessment of where we are is really important. And that it's really critical to have both academic input into that and to have knowledgeable and policy people to be able to use that academic input to make assessments. We can learn from failure, we can improve services, we can think about how we learn, because one of the things that's important to me is making organizations learning organizations, and the way they learn is through their information. And most people didn't use their information. Most police officers didn't use their information as something that enabled them to have insight in how do things really work? Where are we falling down? Where are we doing better? And how can we begin to apply that across the organization, both in terms of learning, in terms of standards, in terms of practice, and in terms of challenges as well. I'll get rid of this. So I'm just going to give you 2 examples. One of the things I did starting in 2004 was what was called the London Rape Review. It was internal. It was highly controversial in the organization itself. It was during a time when actually there was a lot of suspicion about the information that was being used. What I was trying to do over time, and I did this 8 years, not necessarily sequentially in a row, because sometimes I didn't have resources to do it. And it has been last year been reproduced again by the mayor's office. And that is to track allegations of rape over a 2-month period to look at 100% outcome on what happened. And what we can see is that the outcomes are, in terms of justice, really poor. But I also wanted to look at who were the victims, what kind of crimes are they? And one of the things that we know about rape, which is absolutely in the data, is it is not a crime of strangers, it's a crime of relationships, it's a crime of exploitation, it's a crime of vulnerability. And that comes out so strong in the data that it is really important to look at what you've got and then how we take it forward. That is now being taken forward soon to do some work strategically, nationally, for rape in this country. The second thing we looked at was the disorders in London. Now in 2011, when we were awarded the Olympics, there was huge riots in London. What we did, and this is the first time that there was an intergovernmental communication, that government cooperated, cabinet office, education, to look at who was arrested, who committed offenses under during the disorders, and were they all thugs? There was a discourse around whether or not gangs were driving the disorders. We looked at it across the board and found actually it was not gangs that were the majority of the participants, but it was really important to take a look at that. We could do that because I had all the arrest histories, I had all the stop and searches, and we can begin to put, again, data. It was internal to one organization, but we began to look quite robustly about who the people were and what they were doing. So I can take that experience now. I am now thinking about how that applies across justice and using that with data first as a way of really thinking clearly, I think, about what information enables us to think about as administrative data in justice and the possibilities of when that gets linked with other resources, education, health, welfare, mental health, all kinds of things, which is such a rich source of information that allows the barriers around understanding individual journeys with justice, categories of groups of people and differences, identifying problems that actually we might be able to source and resource, not necessarily in justice, but elsewhere, policymakers, analysts, all of whom begin to build a different discourse about what justice means. So if I have any tips for you, I would say follow the people. In the aggregate, the people are really important, and I know Natalie will say more about that later. There is something about thinking differently about public good and public policy. What is better and how is it better? And that, to me, is still embodied in administrative data. And there's some really interesting work being done, again in MOJ, on the technical issues around matching, mining, and meaning, because those things, how do you match up data that were basically recorded by people who necessarily didn't care if you knew what birthday somebody had? So that's really quite important to take a look at as well. So just finally, to just talk a little bit about the ADR UK, it's a really innovative piece of work. It's being funded, a government department is actually being funded by the Economic and Research Council to do this. So now they can actually have a ring-fenced resource which enables the preparing and harnessing of the data in a way that they can't do because of other demands on government and our small little pandemic at the moment, and the kind of costs that would have. So we've been able to ring fence personnel, which is really, really important. That information is now being deposited. So we've got magistrates courts and crown courts, family courts, civil courts are all also in the frame. And there is explicitly thinking about how to promote drive around tackling social and justice issues in terms of this data, and conversations that are happening across government in terms of data sets held by others that might enrich these as well. So I think that's it for now. I'll hand over. Thank you very much.
Thank you very much, Betsy. A fascinating talk, and that point about what is better, what is actually good, is something that we're always struggling with as well in our research. Okay, next up we have Natalie Byram, who is the Director of Research and Learning at the Legal Education Foundation. Betsy, can I ask you to unshare, to stop sharing your, perfect, thank you. And Natalie, if I can hand over to you now.
I will do my very best. You'll have to let me know if you can see this.
Not
yet. 1 second.
perfect.
Amazing. Thank you so much, Matt, for that introduction. And it's a privilege and a big challenge to follow Professor Stanko, who's done so much to advance the use of administrative data for research in the justice system space. So just to say a bit about me, I'm a legal researcher by background, and I'm currently Director of Research at the Legal Education Foundation. We're an independent charity, and I lead work there to try and understand what works in helping people to use the law to secure their rights, protections, and fair treatment. And as Professor Stanko alluded to, whilst great progress has been made in using linked administrative data in policing and to a certain extent across criminal justice more widely, the use of administrative data held by the courts to study the experience of those who access the civil courts and tribunals is still in its infancy. And in this presentation today, I'm going to talk a bit about why this matters, and then draw on the experience of work that I've conducted in England and Wales over the past 3 years, highlight some of the challenges and opportunities in this space, as well as the role for researchers in advancing this agenda. So firstly, what is civil and administrative justice and why is it important? So whilst almost everyone is aware of the criminal and family justice system and what it is and why it matters, the civil justice system is much more poorly understood, despite the fact that it's larger than its counterparts in terms of the number of cases that it deals with, and it affects more people across their lifetimes. So the civil justice system has been described as dealing with the law of everyday life, so disputes with neighbours over behaviours on land, problems with landlords, money problems, employment problems, arguments over faulty goods and poor services, or claims against insurance companies. The administrative justice system deals largely with disputes between individuals and public bodies, so individuals and the state. Administrative tribunals determine matters including immigration, access to unemployment and disability benefits, and access to special educational provision for children. There are also dedicated tribunals in England and Wales that provide a mechanism for patients in mental health settings to challenge decisions about their treatment and for veterans to access benefits. So I think it's really important to say that decisions taken in the civil and administrative justice system are profound and consequential for the individuals involved. The civil justice system can remove you from your home in England and Wales, it can deny you access to benefits, and it can even remove your right to stay in the country. Not many people are aware of this, but in England and Wales, the civil justice system can even send you to prison, for example, if you don't pay your TV licence, or if you're accused of antisocial behaviour, the definition of which has been expanded to include begging in recent years. Failures in civil and administrative justice can and do cost people their lives. For example, when tenants are unable to hold landlords to account for providing safe accommodation, or for when vulnerable asylum seekers are unable to access benefits. We've had cases over the summer of a vulnerable asylum seeker starving to death in a room with her child because she was unable to access the benefits that she was entitled to. So the decisions that are made in this part of the justice system are real, they're consequential, and they're serious. Importantly, from a government point of view, wrong decisions here also have ramifications for public spending. Failure to arrive at correct decisions in this part of the justice system can impose costs on other parts of government. For example, and as Susie is going to attest to in her presentation, unresolved problems with debt and housing can lead to poor health outcomes and increased burdens on public health services. The civil and administrative justice system is less visible and it gets far less attention than the criminal justice system, but for all these reasons, it's no less important. And yet, in spite of the progress that's been made in using linked data to understand criminal and to a certain extent family justice, civil and administrative justice remains resolutely a black box. And the question is, why? Well, since 2018, I've been seconded to the court service in England and Wales as expert advisor on open data and academic engagement, with a remit to advise government on approaches to improving the quality of and access to data held by the court system. At the Foundation, we've also commissioned international reviews of practice in this space. And from this work, we've identified some common barriers to using court data as administrative data in this way, and some emerging opportunities I'm going to talk to here. So firstly, the barriers to linked administrative data research using court data. Firstly, many court systems across the world have been afflicted by what we can commonly term as a tyranny of paper. Most court records are stored in paper format, which makes it really difficult to expensive to access the information that they hold. And there's been a sort of lack of attention at the front end to data quality, to ensuring that data is recorded in routine ways. Another big challenge of using court data is that it's predominantly recorded at the case level, not at the individual level. And that makes it more difficult to apply techniques around matching. And Matthew is an expert in some of these challenges, and he'll be talking about that later. In the case of England and Wales, there's also an acute absence of accurate data asset registers. So when we're talking about what data does the court system hold, the answer we kept getting was actually, we really don't know. And we don't know who holds it, which is really concerning. But having looked at international practice, not that unusual. In England and Wales, at least, there's also been a delegation of data storage to private companies, which increases both the sort of technical barriers to accessing this data and making it available, and the financial barriers. One of the other key challenges that is peculiarly affects court data is the absence of established governance around it. And what I mean by that is really talking about sort of questions of who has the authority to take decisions about whether and when to share the data that is held by the courts. In England and Wales, our court service is an independent statutory agency, but it's jointly responsible to the Ministry of Justice, so government, and also to the judiciary. And because it's responsible to both of those two parties who, due to the sort of constitutional issues around separation of powers, don't really have a forum for making decisions. In England and Wales, the absence of that sort of unified authority to take decisions was really stymieing progress in this regard. There are also a number of cultural challenges and sort of stakeholder nervousness in this space. So there are issues around that have been raised as a challenge to this work around what's the impact on judicial independence, for example, of making more and better data available about the justice system. If you allow researchers to access case level data, will they then be able to predict the outcomes or the decisions that are going to be made by individual judges, and what uses might that be put to? And some concerns about those types of issues have really acted as a blocker in this space. There's also an absence of good empirical evidence to guide decision making about data sharing. So one of the things that we looked at in the international review we commissioned was, okay, so what do we know about in countries where they have made more court data available? What has been the impact on judicial independence? What has been the impact on access to justice? Has this led to a growth in companies claiming to predict outcomes that has sort of skewed the justice system away from the interests of ordinary people? And in the absence of this sort of good, robust evidence about what threats are real and what threats are theoretical and illusory, it's very hard to move forward and make good decisions. And this really matters because we know from experience in health data in the UK that when you make a bad decision, you lose public trust. And once public trust in data sharing is lost, it's lost for good and undermines the whole enterprise. So that's a real barrier. There are, however, sort of several opportunities for this work. So the digitisation of court systems, this is a trend that's occurring globally. It's been expedited to a certain extent by the pandemic. And digitising these systems, moving away from paper-based to digital ways of working, provides the opportunity to actually change the way some of this data is recorded and improve data quality. Other opportunities include the global movement towards open government and transparency, the fact that open government is on people's agendas, that makes it more sort of possible to think about how we might do work in this space. Also, what's been really important and a key enabler for projects like Data First that Betsy leads on at the MOJ is the development of accredited trusted mechanisms for linking and sharing data. So we have shared spaces like the ONS space. We also have the SAIL data bank in the UK, which has really established itself as a world leader in linking and sharing population level data in a way that's trusted. The other opportunities are increasing interest in efficiency. As a result of the pandemic, all government budgets are going to be incredibly stretched over the next 5 to 10 years. We know that that the current system, it's really difficult to work out whether our processes are value for money, and improving the data quality that you have on the operation of the justice system gives you the opportunity to improve efficiency. I think the other point to raise is the events over the summer, the Black Lives Matter movement, which really swept the globe, has really sort of forced people to think again about trust and accountability in the context of the justice system. Justice systems in all countries operate on trust and they operate on consent. And how do you demonstrate that the justice system that you have is worthy of the trust of different people from different backgrounds and groups? Well, the answer to that is through providing data about how it operates and identifying issues of disparity where they arise and using research to challenge them. And I think that movement provides a really powerful moral case for why we need to invest in this work. So what is the role for the research community in driving this work forward? So firstly, there's a vital role for demonstrating the demand for this work, demonstrating that if there were access to data, researchers would be able to produce more and innovative outputs that could actually help to improve the evidence base that the justice system operates on. So that's one way that researchers can assist in driving this forward. The other way is by working with core actors to define what good looks like in terms of management information. So the piece of work that I did for the court service, which was around developing a data strategy that could support access to justice and evidence-based research. Although my name's on the report, that was the result of a concerted effort by a group of up to 60 academics who joined workshops to help define what is the data that should be recorded in new digital systems, and to help increase core actors' sort of knowledge and awareness of how the decisions that they make around whether and what to record can open up or restrict opportunities in the future for evidence-based policy making. And that's been really powerful. There's also a role for researchers in providing examples of best practice approaches and mechanisms, and I think researchers from health and other disciplines can really help the justice community in this space in showing what's possible by the use of this data. And finally, there is a really important role, I think, for researchers to help produce the evidence to support stakeholders to make good decisions about sharing data, to help tackle some of the myths and that sort of act as a cultural barrier to sharing data. I'd be really happy to talk in more detail, but with that, I will hand you back to Matt.
Fantastic, really fascinating stuff. Thank you very much, Natalie. I always get very nervous when someone calls me an expert in anything, but thank you nonetheless. I can see some comments coming through. Please do keep type the questions in straight away. The nice thing about this not being live is that you don't need to hold on to your questions. You just put them in the chat and we'll get to them later. For now, though, we've got Susie Farrell, who is the Research Director of Health Justice Australia, who will be talking about health justice partnerships. Over to you, Susie.
Thanks, Matt. Let me just grab there we go, straight in there. Well, hi everybody. I'm Susie Farrell, I'm at Health Justice Australia, and Health Justice Australia is the National Centre of Excellence for Health Justice Partnership, which I will tell you a bit more about what that is. And I think what's been interesting is that Professor Sanko has taken us to police data, Natalie has taken us to court data, and the sort of data I'm going to talk about now is legal assistance data, which is the data from the often public legal assistance services that help people even with matters that may not even get to court or get to the police. There we go. So what I'm going to first do is give you a bit of an overview of what health justice partnerships are, and then my talk's really going to talk about the types of questions that we could seek to answer about the relationship between health and justice and what are the data implications of that. So health justice partnerships are partnerships often between health and legal assistance services to embed legal help in healthcare teams, with a particular focus on assisting people with legal problems that harm their health, but also who face barriers in accessing assistance for those issues. So the types of people that these might include are women using maternity or baby health services who are experiencing family violence, people living with mental illness who have issues with housing or maybe accumulated debt, fines. Older people vulnerable to elder abuse, including financial abuse, and children getting ill from asthma, from mould in substandard housing. In the UK, these kind of relationships are often understood as welfare advice in GP clinics, and in the US, they're described as medical legal partnerships. And broadly, it's important to say that this partnership responds to evidence both in public health and in access to justice. So broadly, the recognition of the social factors beyond the medical that can affect people's health and well-being. And in access to justice, we see the concentration of legal need among the most vulnerable. We see the clustering of legal need, and we also understand that people with unmet legal need do not necessarily seek help from lawyers. And it's really the same group of people who end up being the subject of these two quite separate bodies of research. So in Australia now, there's probably around 100 services on what we call a health justice landscape, and I'll come back to why that's important. But this sort of shows you the distribution around the country. And important to say that where there are services in remote Northern Territory, far north Queensland, to inner city parts of Melbourne, Sydney, Canberra, Perth, Adelaide. To understand the data implications, it's important to understand the organisations and agencies involved. So on the legal side, as I said earlier, the vast majority are public legal assistance services. So legal aid commissions, community legal health, community legal services, family violence prevention legal services, and Aboriginal and Torres Strait Islander legal services. And again, these are services that are all operating on, there are some shared data systems, but there's a number of different data systems in that space. And what we're seeing is legal help provided in health services as diverse as community health services, Aboriginal community controlled health services, hospitals, and other community settings. So you're seeing already in a federated system like ours, some of these are state-based services, some of them are federal health services. So there is a lack, data doesn't speak to each other within either of those silos, and we want data to speak across those silos as well. So there's some of the challenge we're facing. We also, health justice partnerships also involve a range of activities. And again, these are activities we want to see in data. So firstly, legal help is provided in the health setting or team, so in the health space. And as I said earlier, that can be for issues as varied as family violence and family law, child protection, fines and debt, housing, tenancy issues, elder abuse, and some criminal matters. But other parts of the value of health justice partnership, or the work we want to see in data, is also the interdisciplinary training and cross-disciplinary referral. And that's important because that's about increasing the capability of partner services, for example, increasing the capability of health services to identify and address health harming legal problems. Interestingly, there are new activities in health justice partnership that don't necessarily sit in either data system. So things like secondary consultation and coordinated care. So while we have in legal data systems, for example, you can identify what an advice is or representation or an information service, there is no shared definition of secondary consultation. It's an evolving practice that is not well defined yet. And yet it's really part of the value of this way of working. So again, this is something we're really interested in understanding how we can better define. And that's part of the work of us as the National Centre. We also want to link all this activity to outcomes. And I think what's also interesting is that outcomes look different depending on which way, from where you look at them. So for a legal service, the value of coming together in partnership is to reach, one of the values is to reach clients who are vulnerable to legal problems who are not seeking help. When you're looking at success from the health point of view, you're looking at the value of being able to address these issues that are affecting people's health that you don't necessarily have the tools to do as a medical service. And for clients and patients, they have a different view of success. Again, it's about getting integrated care for their intersecting need. And we're actually interested in what success looks like for clients of this way of working. And in bringing together health and legal services, we're also interested in creating a dialogue about what are the shared outcomes? What does it look like? What is the value beyond the value to the legal service and the value to the health service and the client? And we think the shared value, the difference they can make working together is to improve well-being. So that brings in another metric to consider and another piece of data to potentially link into the story. So health justice partnerships are not a system. They're fairly small interventions at this point. It may be a lawyer working several days a week in a health service. So they're not service-wide and they're not population-wide, which creates another sort of data challenge for us. But we think there's scope to ask some really interesting questions here. And one of the questions is, what is the impact of legal help on health outcomes? So if you stay within the legal assistance sector or in the legal sector, you tend to be thinking about the value of legal help in access to justice terms. If we're able to ask the value of legal help in broader terms, we speak to a much broader audience. So we're really interested in exploring what does legal help offer to health outcomes. And so the opportunity is to compare a health service with a lawyer involved and to a health service without a lawyer involved. But the other question is, does integrated help look different to siloed services? Is there value in these services actually working together? So does integrated help produce better outcomes for the legal services, for the health services, and for the client? So they're the range of questions we're really interested in. So in terms of the types of data that you want to ask, so again, I want to stress that you're asking a what works question. So you need to know the questions that you want to know about the what, the activities, as well as the outcomes, the working. And so for us, we're interested in there's activity and legal assistance data. So the types of services provided by the lawyer, the matter types, as Betsy talked about, you want to follow the person, what types of clients are being reached, and with what type of matters. We want to look at this new activity, this secondary consultation, the types of training. It's sort of program data. It doesn't sit necessarily in some of the administrative data. And there's activity in the health administrative data as well. And then in terms of the outcomes, that's not routinely collected in legal assistance admin data. So you're starting to collect new data, survey data. And potentially, if you're interested in what is the impact on the efficiency of the health service by dealing with these issues, these social issues that might be holding people and preventing their recovery, you'd be wanting to see linked to that data as well. Of course, this raises a whole range of challenges. To begin with, as I said, health justice partnerships are a relatively small activity. We need to be able to see them in the data. And as they're not all exactly the same, we have a variety of ways of coming together. We want to see features of that way of working as well. Yes, there are challenges in defining outcomes. So we've actually, part of our work as the National Centre is to be bringing health and legal services together to have a discussion about what is the difference you're seeking to make. Because while there is some shared, there are shared outcomes, often the language around those outcomes is a bit different and people are using different metrics. So what we're trying to do is get more consistency in the outcomes that people are describing and then the metrics they're using to describe those outcomes. And for some of these outcomes, there are no tools. So again, we're now looking also at creating new tools to identify different types of outcomes. And then, of course, we've got the challenges, as Betsy and Natalie have both identified, there is real challenges within any one of these sectors in consistency and quality of data. But when we're trying to link across sectors, we have that other added challenge. Also, we're also dealing with the issues like confidentiality, of course, and information sharing. Again, that would be familiar issues the others are dealing with as well. And I guess one thing that we've really come across is just different use of language. What does an advice mean? And the way a lawyer talks about advice is very different to the way a health service provider will understand advice. And of course, we've got real issues of very differing data capability in the legal assistance sector compared to the health sector. what's been important for us, I mean, for us, it's been a lot of discussion between within the legal assistance, the various legal assistance practitioners we're working with, but also to have that dialogue across health and legal and the various health services we're working with as well. And I guess one way we've been trying we've really gone back to the client at the centre as that's where the shared interest lies. So I'm going to actually stop there, and I think it might be easy to pick up some of these issues in the questions a bit later. But I guess one thing I'd say to the audience in here is that there's some really exciting data linkage opportunities. We are looking to really connect with others around the challenges that we face, and we really invite others to get in contact with us if you've got thoughts and ideas about how we can progress this really well. So I'm going to stop there.
Lovely, thank you very much, Susie. And I believe that the recordings of these sessions are available for 6 months, so you can get these slides later and find our contact details. You say it's a very small service, but these are crucially important services, right? You know, when you become ill, that's the point at which you need legal help lots of the time. And so small, but fundamentally important to so many people. So now I'm going to hand over to myself. I'm Matt J, as I said before. Let me share my slides first of all, make sure that works. There we go, full screen. I hope you can see the, perfect. So yes, I'm a PhD student at University College London and the founder of the legal epidemiology group there. And what I want to talk today about is legal epidemiology. So this is the integration of the study of law and legal processes with epidemiological methods. And the reason I got into this is because, I mean, my background was in law, and I practiced as a welfare rights advisor in something which is probably just short of a health justice partnership at Great Ormond Street. And then I became a social epidemiologist almost by mistake, and realized that what we're missing in law basically is the research evidence, the empirical way of doing things. And part of the problem is that lawyers just are simply not trained in empirical methods. They're not trained in well, I guess scientific methods, in collecting data, making observations, experimentation, and then integrating research evidence into their practice. So this is a fairly typical English university undergraduate law curriculum for the first year. You know, you do your 7 core subjects. You have to do those subjects in England. It's probably similar in other common law jurisdictions. So you do, you know, contract, you do crime, property law, and so on. And you learn the statutes, you learn the case law, and then you apply those rules to facts of cases. Then when you go off to do your professional training, you learn how to actually navigate the court system, become an advocate, fill out the forms, whatever it is. But at no point do you do what I guess we would call a scientist. You don't do research methods, or at least scientific research methods. And so there is no culture in law, really, or in legal professions of, obviously I'm generalizing, but this is, I think, pretty much true across the board. There's no culture of using research evidence in practice. And so we don't really, a lot of the time, we don't really know how the law is working and the impact that it has on people's lives. And so this is a quote, I mean, Natalie used the phrase black box earlier. This is a quote from Sir James Munby, the former president of the family division of the High Court in England, so the most senior, or formerly the most senior family judge in England. And he said, we're operating in the dark. You know, we just don't know what's happening to the children and families who come before the courts. And this applies both on a sort of individual case management level, you know, so deciding, should this person be convicted? What sentence should they get? Should this child be taken into care? Should this person get benefits? Whatever. It also applies, though, on a more broader population policy level as well. We very often just lack the evidence. And so one way of getting to grips with this is to adopt a public health approach to law. And doing this forces us to look at law in this way. It forces us to recognize, first of all, that there are populations, there are groups of people who are subject to law. Well, everyone's subject to law, but there are groups of people who are more likely to come into contact with law and legal processes, whether that's in the courts or whether it's other public bodies who are administering law in some way. And then we have outcomes. We have short-term outcomes like conviction rates. But we also have these longer-term outcomes like the impact of law on health. I mean, as Susie just mentioned, you know, law does affect health. Whether or not the law in question was designed to do that, it can have those impacts. And all of these things happen over time. There's a temporal element to this, you know, what happens to you early on in life, we know from years of research in epidemiology, can have major impacts on your health and your well-being much later in life as well. And looking at law in this way, a number of things jump out. Two main things jump out in my mind. One is, first of all, that we can view law and legal processes, legal services as intervention points. So if we want to improve public health, law is one mechanism by which we can do that. The second thing is it becomes much clearer where we need the data. So we need data on populations, both on those who do use legal services, but also those who don't. So we need to understand the populations where people are coming from and making sure that people are getting the right services that they need. We then need data on the legal processes themselves. And this is where we tend to have quite good data, or the best data we've got in this field anyway. You know, we have lots of data on things like numbers of cases coming before the courts, and then also the immediate outcomes of those. So we have lots of data on, as we saw, you know, conviction rates, children going into the care system, and so on. Where we really lack data, or rather I should say, where we really don't routinely collect data or don't routinely link data, is these longer term, broader outcomes like health and education. We can, of course, we can link data. We can link data to get these longer term outcomes, and we can link data to get whole populations where data sets are available. Now, a lot of the work that we do in the Legal Epi group is around children's social care. Well, pretty much all of it actually is around children's social care in England. And this is a system administered under the Children Act 1989. And basically there are three main sort of bits to it. First of all, we have children in need. So this is a large, very heterogeneous group of children who require help from the local government to support their health and well-being. We estimate that about 25% of all children born in England will become a child in need at least once before their 16th birthday. So a very large group indeed, and it's about 4 or 5% cross-sectionally each year are children in need. We then have the child protection system. So this is where children are at risk of significant harm from their parents, essentially, and the local authority or the social care services of the local authority have a duty to investigate and to put in place measures to protect the child. And then we have the care system, or the system for children looked after, the mainstay of which is foster care. And this can be a response to child protection concerns, but there can be other reasons as well. For example, unaccompanied asylum-seeking children who don't have parents in the country or anyone to look after them will also be placed into foster care. And if you think about data sources, I mean, there basically isn't a unified data source that covers this whole system. We have, I mean, I've put 3 here, you could possibly think of others as well, but these are the 3 main ones. So we have the child in need data set. That's this big, I don't know if you can see my cursor, probably not, but this big grey bubble at the bottom. This contains data on all children referred to social care, all children in need, and also all children on child protection plans. We then have a separate data set, the child looks after data set, which contains all children who enter, all children who become looked after in England. And this is England, I should say this is England only. There are different systems, different data in the other parts of the UK. The children looked after data set, as I say, is separate from child in need, but conceptually these children are a subset of children in need. So there is obviously this massive overlap between them. We then have the CAFCAS data set. CAFCAS is a court-based social work organisation. They represent children who are going through court proceedings to do with carers, so being taken into care, as well as some other things not to do with the care system. And they also collect data. And so what you can see is that there's this mishmash of data which covers both judicial and non-judicial legal processes affecting these children. Now, one of those longer term outcomes that we're looking at is education. Now, I don't think I need to convince anyone that education is fundamentally important for all children, but within a social care sphere, there is a particular legal consideration that's additional to that, to the moral imperative, and that's the welfare principle. So it's this idea that in any decision concerning the upbringing of a child, the child's welfare is the court's paramount consideration. And there are other provisions within the statute addressed to local authorities that say more or less the same thing. What is welfare? Welfare is, according to case law, is everything to do, or pretty much everything to do with the child's well-being, now, i.e. at the time the decision is being made, and across life. So although the statute doesn't use epidemiological language, it does adopt a life course approach to decision making, or rather should do. The problem is legal decision making simply doesn't work that way. You know, in the lawyer's mind, the judge's mind, they have a single case that comes before them. They make a decision. They try to make a decision that's consonant with the child's the child's welfare as the paramount consideration. But then they don't really know what happens afterwards. And this is something that we hear from, you know, judges say they don't really get feedback on their cases unless the child happens to come back. They don't know what happens to them afterwards. And when we speak to people, we've interviewed people in local authorities, and they say to us that one of the things, you know, the major missing jigsaw puzzle piece is the long-term outcome as well. So my contention is we just simply don't really know whether or not we're meeting this duty to treat the child's welfare as a paramount consideration across the life course. And when it comes to education, there are very well-known problems. You know, the fact that children, here we've got children in care compared to children not in care. The grey line is children not in care, the blue is children in care. It's well known that they consistently underperform in their exams at school. So here we have the official statistics from the Department for Education. This is the proportion of children achieving 5 A stars to C grades at GCSE. That's England's sort of, well, used to be the school leaving exam essentially. I mean, you can see massive underperformance across time. And no matter how you can cut these data in pretty much however you want, no matter how you do it, you see the same thing. Now, we've been looking at special educational needs because one possible reason for this is, of course, is that these groups of children are different groups of children. And what we found is by linking the child looked after and the child in need data to a database called the National Pupil Database, which I'll talk about a bit about in a minute, we found that of all the children who were ever in care at least once from year 1, that's about age 5, to year 11, so roughly age 16, of all of those children, 83% of them at some point across that time period received provision for special educational needs of some kind, and 65% of children in need. And so we see absolutely enormous overlap in terms of, you know, the population served by social care services and served by these special educational needs services as well. One area that's been relatively understudied is participation in education. So are children, basically, are they going to school? Are they actually in school? And so we're using the National Pupil Database, and this is a data set covering the whole of England, and it contains data on all children in English state schools, so not private schools, but all state schools. And we've linked it to the social care data. And basically we're following up 1 million children from year 1 to year 11. So again, from age 4, 5 to age 16. And we're looking at their social care exposure across the primary school period. So from age 5 to 11, and then looking at whether or not they're in school along a number of different metrics from age 11 to 16. So their secondary education. And of these 1 million children, 1% are looked after, 0.5% were on child protection plans, but not looked after. So these are exclusive hierarchical groups. 6.5% were children in need, but not on child protection plans, not looked after. And the rest had no record of social care involvement. And here are 4 of the outcomes we're looking at so far. These are cumulative graphs. And so if we look at the top left panel, first of all, headed absence, this shows the cumulative proportion across secondary school of children who are persistently absent. They miss at least, they miss more than 10% of their schooling in any given year. And what we see is this turquoise line at the top, that's the children on child protection plans. From across year 7 to 11, 65% of them will have been persistently absent in at least 1 year, followed by children in need, the dark green line, followed by children looked after, and then the non-group. So absolutely enormous, rates of absence among these groups. We then see similar things for fixed term exclusions, or similar patterns, I should say, for fixed term exclusions, permanent exclusions, and then not being enrolled. Not being enrolled is very interesting. As I say, because you're not enrolled in a state school, you could be enrolled in a private school. You could be homeschooled. You may have emigrated. There are legitimate reasons why you wouldn't be in a state school. But the fact that we see an uptick of children not being enrolled in years 10 and 11, so the final 2 crucial years of secondary education, it's not proof of it, it's indicative of something called off-rolling. So this is where a school essentially ejects a child from the school for illegitimate purposes. So it's an illegal practice, very, very difficult to detect. It's to do with things like skewing your league table results as a school. The fact that we see an uptick of it is indicative of that. So this is very concerning. This is all work in progress. We intend to look at special educational needs and also variation, because although those definitions of child looked after, child in need and so on, they are national definitions, but there's a huge amount of discretion left to local authorities within the law to administer the system how they see fit. And so therefore we also see, unsurprisingly, a huge amount of variation, both in terms of rates of, for example, children going into care, which may be driven by local authority factor, that may be driven by the underlying population, we don't yet know. And also variation in terms of these outcomes as well. So we're currently exploring that. I haven't got time to go into this in detail, but this is work from my colleague Rachel Pearson. She presented the underlying linkage work, the technical stuff on this yesterday. So I invite you to look this up. It's in the child protection bit of the conference from yesterday. She links the CAFCAS data to mental health data for South London. And the point I want to make here is that the family is important. Anything to do with children, the family is going to be important. And with some data sets, not all, but with CAFCAS, we can get the family link. And so that's one of the really, really useful things about some of these admin data sets. And one area where all admin data sets could be improved is by collecting family data as well. We can also use the scale of these data to understand underlying heterogeneity. So that, these groups, child in need, child looked after, mothers of children looked after, they're not homogeneous groups. But we can use these data, we can use models. So Rachel used latent trajectory models to try and identify, in this instance, mental health service use before and after court proceedings. So we can identify different groups of mothers who would benefit from earlier healthcare intervention to enable successful parenting. There's some references and further reading here, and we've produced loads of data resource profiles which show you some of the strengths and weaknesses of these data. So if you're interested in using these data sets, obviously it's all very English focused. That's where we are. I apologize for that. Check these out. I appreciate none of these hyperlinks will work for you when you're looking at the recording, so feel free to email me and I'll happily send out the references. And I'd like to thank Department for Education and ONS, Office of National Statistics, for the data, my funder, the Medical Research Council, and all the data, the children, well, basically every child in England, because we use all their data. So thank you very much. That is me. So now we'll open it up to Q&A. Oh, loads of questions have come through. Fantastic. So I'm just going to go from the top as they've come, as I see them on my screen. So I think if all the panelists could please, I think you can unmute yourselves now, possibly. I don't know. Well, actually, the first question is for Betsy. So, Betsy, how much is this data used? This is from Jason Burke. How much is this data used to drive legal reform? Or was this mostly focused on enforcement of existing laws?
It was a bit of both. It was important to try to, I would say for the first 10 of my 14 years inside Metropolitan Police, it was getting the police service to understand the value of the information. So it was used much more to drive systematic and strategic change, but it did also begin to ask questions about, for example, knife crimes and other kinds of specific issues that you could research in the data itself. So I would say more understanding legal enforcement, but also understanding non-enforcement. Again, with the rape allegations, the most common outcome is no prosecution.
Thanks very much, Betsy. Next question from an anonymous user. So interesting presentations, thank you. Could you please comment on how GDPR affected the technology aspect of legal research you are doing in the EU? I guess that's for all of us. I'm not quite sure in terms of technology if that means sort of things like apps and AI and algorithms and so on. I mean, I can talk a bit about getting access to getting hold of data and how GDPR affected that, but I don't know if anyone else wants to jump in first.
No,
Go for it, Matt.
Yeah, well, I mean, when GDPR came in, I mean, I was applying for data at the time, and it put a moratorium on everything, and so it caused huge delays for me. I think what GDPR has done in terms of actually getting hold of data in the first place, certainly for Department for Education, so for the NPD data and the social care data, they have become much, much more rigorous, but it did trigger them to instigate a new system, which I think is definitely safer and I think will be more efficient. I'm cautiously optimistic, but it can still take years to get hold of data. I mean, in terms of technology, I was actually going to ask you, Betsy, about policing by algorithm. I mean, you didn't talk about this, so maybe it's not something that's fair to ask you about. But obviously, we hear all the time, and in last year there were reports of, I think it was maybe West Midlands police who are adopting an algorithm to try and predict who's going to commit crime. We hear these kinds of minority report stories. I mean, and that obviously raises very serious ethical considerations. So what's your view, if you have one, on sort of where ethical oversight needs to be in terms of using police data and these kinds of algorithms?
This is absolutely critical. I think that any algorithm needs to be understood, both for the way in which possibly reproduces bias. And so oversight is really, really important. And the work done, there is a Center for Data Ethics now, and algorithms do need to be checked, and they need to be checked for the way they reproduce, arrest to conviction, etc. I think we certainly ways of taking a look at where crime was reported more. So remember, it's not prediction of crime, it's prediction of where people already tell the police that crime is occurring, because that's what a crime record is. It's not something that predicts out of the blue. It's using information that's already generated by the police themselves to say, where is there more of what we're trying to look at? So that's also an issue that needs to be discussed in terms of algorithms and how it's used, in particular to try to issues might be being reported by people, and that's what crime records are. It's being reported by people, and police begin to think about, well, what does that mean in terms of using that information?
I think, if I may, so at the foundation, we've led a whole program of work on the use of automated decision making in public policy more broadly. And I think it's important that although the most high profile examples are often in the police, these technologies are being used in children's social care, for example, and there's been some really good work carried out on the sort of impact of those on outcomes for children, and I think we are going to see more of this in terms of the drive towards efficiency. Perhaps linking this to the previous question about GDPR, I think data protection impact assessments are a really underutilized tool at the moment in terms of providing a level of transparency and scrutiny for these types of technologies. I would really like to see the ICO do more to work with actors to improve the quality of those impact assessments, because I think they can be a really helpful tool, but like equality impact assessments, they're only as good as the person filling them out, basically, and there needs to be more teeth on that. In terms of GDPR in general, I don't know what the regimes are like in Australia, Susie, but I know certainly for our grantees, I think GDPR has had a kind of chilling effect on the willingness of lots of the smaller organisations that the foundation funds to use and work with their data. When GDPR came in, we had grantees who were so terrified of the idea of being fined or prosecuted, and that they were literally sort of torching their databases of contacts and this really rich potential source of data that they can use to improve their own services was just being destroyed out of fear. And so I think there's a really important role in terms of making sure that, because if you notice, none of the private companies that we might be concerned about their data practices did that. They all just issued privacy notices, whereas you had a lot of smaller charities who were just so terrified that they took these actions. So I think there is a really important role for the ICO in making sure that everyone actually understands the asks that GDPR makes of them, and sort of making sure it doesn't have a chilling effect on the conduct of research.
Thanks very much. The next question is for me. Do criminologists not provide some of the research required by the health justice system? Yeah, so I probably should have, to be fair, I should say that, these things I talked about, it probably does vary from legal area to legal area. And certainly criminology is a very well-established discipline in its own right. I'm not a criminologist and I don't read much criminology literature, but I certainly wouldn't be surprised if they have produced a good amount of work in this area. And certainly, and of course, there is lots of, really good quantitative criminology work coming out as well. So apologies for sounding very monolithic about this. That wasn't my intention.
I'm a criminologist too. So yes, criminologists are certainly asking these questions, but there is, perhaps less focus on civil law issues though.
Yeah, absolutely. Yeah. So next question, thanks all. How do you see health justice partnerships developing or improving over the next 5 to 10 years? Is there a sense of buy-in to building stronger, truly integrated services, brackets at population level, beyond the smaller partnerships that have been alluded to? From Anonymous.
Look, I think there is. I think the thing about health justice partnerships is they are a strategy to deal with really complex issues. And so they serve a particular part of the population. And so there is, I think what the opportunity we've got is to learn from the partnerships we've got, to look at their value, but I think also acknowledge that health and legal services come together in a whole range of different ways. So at the more population level, one example is just thinking post-COVID, we know, the mental health impact of a range of issues, financial issues, mortgage, a whole range of issues affecting at a population level. And so as you're rolling out population-wide mental health or mental wellness strategies, how do you link in legal assistance to those and the recognition of the impact of the things that are causing the stresses to people, rather than just dealing with the feeling of stress once you have it. So yes, I think there's lots of different ways that health and legal services can come together, and part of our work is to start this conversation and to really start to think of the various ways that we can actually bring health and legal services together around supporting people and improving lives.
And just to follow up, we've been really inspired by the work of Susie and Tessa in Australia in the Health Justice Centre in the UK. So the foundation has funded the development of a national strategy for health justice partnerships in the UK, which is led by Professor Dame Hazel Genn at UCL. And we are really working on, because I think what's interesting, if you look at across the UK, there are lots of different examples of health justice partnerships on the ground, but it's not centralised, it's not organic, there's not a standardised model. And there's a leap that needs to be taken to move this from like local good practice to a national agenda. And I really hope that, given all of the brilliant work that sort of Susie and Tessa and Hazel have done on sort of demonstrating how these can be an effective tool in improving public health, we'll really see some more sort of moves to that, as well as like reducing inefficiencies and improving the cost efficacy of services. I really hope that we'll see some sort of buy-in from the government in the next period on this.
I think, Natalie, to add to that, though, the data challenge will be that these won't scale as an intervention that looks the same in every place, and it necessarily needs to be different. So part of it is understanding how the interventions will vary, as well as what the outcomes look like. And I think that's going to be a really interesting exercise as well.
Exactly. What works for who, where.
Exactly. Yeah. And what it looks like, what it takes to do it.
Lovely, thank you. Before I ask the next question, so Rachel, whose work I mentioned in my presentation, hello Rachel, I see you're here. She posted in the discussion forums, not the Q&A, so I don't know if anyone else can see, I hope you all can see that. But she produced a really good presentation actually on that trajectory stuff that I showed in my slide. So she's very helpfully put the link there for us to to check out at our leisure. Thank you for that, Rachel. Okay, last question in the queue is from Sean Wiseman. So Natalie briefly mentioned open data. Is making legal or case data open and finding open data in this space as challenging as it is in the health field? Are there different challenges? Or anyone can comment. Great presentations, thanks. Thanks, Sean.
That's a brilliant question, Sean. Short answer, yes. And I think some of this is, so in the UK, we delegated, oh, sorry, I'm getting a bit of feedback. In the UK, we've delegated the role for providing access to case law to a large extent to for-profit providers. So the most comprehensive collections of case law data are held by private companies like LexisNexis, Exam, Thomson Reuters, etc., who put them behind a paywall. And where we do have organisations that provide open access to, or free access to case law, like the brilliant Bailey, our Legal Information Institute. And the issue with that is that it's incomplete, and due to the litigation risk entailed in sort of making that data open, because Bailey's such a small charity, it can't take the risk of making that data free to download in bulk. I do think that in the sort of case law legal, I guess it's kind of what I alluded to in my presentation, that at present we really do not have a good understanding of what are the risks and the likely risks and benefits of making case law available to download in bulk. And I think certain actors in our system, so the judiciary, have looked at the experience of countries like France, where they made a lot of data available on an open basis, were really shocked by the growth in the use of in private companies who are trying to use that data to predict case outcomes. And what that then led to was imposing criminal sanctions on anyone who used the data in that way. And so I think there's some more work that needs to be done on what are the risks of making data available in bulk for research? What are the potential benefits? Who gets to decide how we balance those? And how do we ensure, one of the issues at the moment is, if you can afford to pay for access, like there's a big law firm in Mishcon-de-Reya has just bought bulk access to Justice, the largest legal case law database of UK case law in the UK, and they are now therefore able to do all the types of data analytics, data mining, predictive analytics work that they could want, and that's available to them because they had the money to pay for it. And I think we really need to inject a level of realism in terms of the people who are taking policy decisions on that. Is it okay that if you have money you can do that, but not if you don't have access to the resources to pay for that data? So I think there's a real need for some sort of urgent policy attention to look at this, and I really hope that this is something that our government and HMCTS are going to look at over the next period. Really long waffly answer, apologies everyone.
Thank you very much. I think so we've answered all the questions, and I have obviously not read out all the comments, the very kind comments that the folks have been posting, thanking us for the session. We really appreciate those. I think we're very nearly at the end of our time now. I think I'll very briefly just to wrap up, unless there's anything else that anyone else wants to say. I think in my mind, coming from both a law and I start having a law and a kind of a health background. I look at sort of data and law, I think of us as, decades behind where we are in health. And I think that probably is fair. Again, I'm seeing some nods from Susie. Yeah, so, we are decades behind. And so, but what's really exciting is that, we can learn from health, we can learn from other sectors, and sort of, hopefully catch up relatively quickly. We'll see. I'll stop talking. There's a danger of me waffling, so I'm going to stop now. I'm going to thank all the speakers. Thank you to all delegates who are here and all those who will be listening to the recording later on. So that just leaves me to say, well, good morning, good afternoon, good evening, and good night. Thank you very much.